On your test, hopefully you all have picked up your test. I tried to provide the correct answers for each question that you got wrong. Let me go through real quickly with you the test questions that you can expect to see again throughout the semester. Number 3.
Oh, you're telling us which ones might come up again?
You can expect to see sometime throughout the remainder of the semester, question number 3. You can expect to see number 13. You can expect to see number 14. Number 19. Number 23. Sounds like bingo. Number 25. Number 26. Number 32. And number 46. Now, these questions,
I was just gonna ask, so when you say show up again throughout the semester, are you meaning test?
yeah, right, yes. Doesn't mean they all will be on the same test, and there may not be any of them, but I'm just giving you a heads up. And because in regards to the test that's next week, 98% of it is just over the material in this Unit 2, Chapters 5, 6, and 8. However, there may be a question or two on the material we just finished. Understand? So in a very smart way, I guess you can say it's comprehensive, because it might include a question from Test 1.
Like how a book refers back to,
Pardon me?
like how a book refers back to,
Yeah,
previous chapter.
sometimes, yes. Now, if you have any specific questions about your test, I prefer to deal with you just individually. And so either at the break or after class, bring your test up along with you and we can talk about them. However, as I said before, I tried to provide you with a correct answer. Hopefully you can read my writing. And while you can come up and talk to me about it, the chances of getting it changed are slim at best. This will be the first class that I have allowed you to keep the test.
All right,
Maybe because of the fact this might be my last class.
that's fine.
And if it isn't, then I can always change my test. Probably needs to be changed anyway. I've been using it for a while. But I thought it was a good test. I didn't figure anyway that I needed to change it.
Can I just address one question, because it seems like we all got it wrong, because we all took the same notes, and number 25 is cannot appeal. And in my notes and his notes, we both put down cannot appeal. You never said that the defendant could.
Oh, the defendant is.
Oh, I think we could have a debate about that. But I will be the final arbitrator on that. I know I did. Well, you don't have to support me. Just the fact of the matter is, notice the question is this. A small claims action is filed in the trial or superior court. You see, okay, just like other civil actions. However, the small claims action is unique from other civil cases in 3 ways. And what are those?
You kind of gave a hint when you said not easy, quick.
Well, I should have given you the
The
hint.
other one, the other two
Sure,
worded, you're-
sure. He's just asking the question about, you know, the idea that only the defendant can appeal. He just wrote in, since he's the one who asked the question, can't appeal. And I marked it wrong. The defendant can appeal.
Yeah.
Well, yes, I know that. Excuse me.
That's exactly what I
Okay. Mr. Christensen?
Thank you, I was just wondering, because we both were checking our notes.
That's not everybody.
Well, just saying our notes.
Well, obviously, you're writing the same notes. So be a little more careful in your note writing. So just keep your test. I don't think it's gonna be worthwhile for you to spend a lot of time on in the future. You can do with them as you please. I've given you the possible questions that might come up throughout the remainder of the semester. Any questions? Yes?
Since we are in 25, for the people that did no right, no appeal, what's the correct answer?
Defendant can appeal,
Oh, that's,
Plaintiff can't.
Plaintiff cannot defend the claim.
or you could write it plaintiff cannot appeal. But either one, you have to have it in there. Okay. I gave you a real quick overview of the grades on the test. My attention always goes to these two, and I never have the time to really understand why it didn't work for you. All I can say is don't give up. If you looks like there are a few already have, but if you fall within this group, just put in a little extra time, and we'll try to get you through the semester. Okay, review from last week. So let's look at it. It's entitled Review of Week 4. It's the last page on last week's handout. The last page on last week's handout. I want to go through these rather quickly, and then I'm going to have some questions I put on the board, and there's a lot of duplication, and we could move fairly quickly on those too, but I always think repetition is sometimes the best teacher. So, letter A. The last page from last week's handout, not this week's handout, last week's handout. The U.S. Constitution is the primary source of law, and it establishes the basic structure of the American society's national form of government. Another word for national could be central form of government. Number one, what do we call this form of government that's established by the Constitution? Federal. Federal. Number two, what is meant when the U.S. Constitution is referred to as the supreme or highest law in our society or in our land? What does that phrase mean?
The Supreme Court is the highest authority.
Well, that's certainly true. That's Supreme Court. And most of, if not all of the constitutional law comes from the Supreme Court. What it means is that neither Congress, which you know is the legislative branch of the federal government that makes laws, neither Congress nor any state can pass a law that changes it or conflicts with it. While it's not written in stone, it stands at the top of our legal system. Can't be changed by Congress or by any state. Yes.
Last week in the definition, you used it as the benchmark.
Well, yes. It's a benchmark for what purpose? What is a benchmark?
Well, all laws are set up to.
So benchmark is something that's established that is referred to in making some kind of decision. The Constitution is the benchmark that the U.S. Supreme Court uses when making decisions, cases that come before it. But that benchmark can't be changed by Congress or any state. That's why it's the supreme law of the land. Number 3, how would you describe the relationship the national government has with individual states under the Constitution form of government? What's it called?
Partnership.
A partnership. States have delegated a few powers, just a few, over to the national or federal government, the central government, and they keep all the rest of the powers. And so wherever the issue lies, it's either a federal issue or a state issue. The Constitution clearly distinguishes which issues fall where. But they're treated as a partnership. They try to get along together. Sort of like entering into some kind of a relationship with another person. It would be a good idea that you lay down some understanding as to what you're going to do in the relationship and what the other person's going to do in the relationship. Don't just let it happen by accident, because usually accidents end up in bad situations. If you're going to take care of the finances, then make sure the other party agrees. If the other party is going to be buying the groceries, then don't go out and buy groceries in addition to what they're buying. In other words, establish what your relationship is. It's a partnership, just like the federal government is to the state governments. How would you describe the most important reason for the making of the U.S. Constitution? What the framers were primarily concerned about, and they wrote the Constitution with that in mind. What are they trying to do by writing this Constitution?
Regulate interstate commerce.
No?
Protect
Good
the
try.
people from the government.
Okay.
Freedom?
Say that again?
Protect the people from the government,
What government?
the federal government.
The government that they're creating by the Constitution, exactly. Protect the people from the government. They just fought a war to get rid of a government. And now they're going to create another government, so they want to be sure that the people of the nation are protected from that new government. What are the 3 branches in the national government? Or the federal government? Or the central government? What are they?
Legislative, executive, and judicial.
Okay, executive, legislative, and judicial. What's the main job of the executive branch? Enforce the law. What's the main job of the legislative branch? Make the laws. And what's the job of the judicial branch? Interpret the laws. When conflicts arise between the branches of the national government, how are these conflicts resolved? That should probably be by whom are these conflicts resolved?
The court.
The U.S. Supreme Court. Number 7, what did the case of Marbury versus Madison in 1803 establish?
The Supreme Court has final word.
That's right. The right of the Supreme Court to resolve conflicts. There's nothing in the Constitution that tells who's going to be able to resolve the conflicts. So in 1803, not too long after the Constitution was finally adopted, the Supreme Court had the case come before it, and the issue was who's going to make the decision, and the Supreme Court decided it would, and it hasn't been challenged since. Number 8, constitutional law comes from which branch of the national government, and what function is being performed that results in constitutional law?
Administrative agency?
No?
Judicial?
It is the judicial branch of the government. And what they're doing is they conduct reviews, primarily the Supreme Court, of cases, and they interpret the provisions of the Constitution to the facts of the particular case. That results in constitutional law.
So can you,
Constitution plus judicial branch plus interpretation equals constitutional law. A formula.
Constitution, judicial branch, and what else?
Judicial branch, no, what did I say first?
Constitution, judicial branch.
What was it first?
Constitution.
Constitution,
Uh-huh.
plus judicial branch, plus interpretation equals constitutional law. Now, here's an important question. How would you describe the impact on the doctrine of stare decisis in constitutional law as compared to law made by the courts not involving the U.S. Constitution? That word should be not and not now. It isn't changed to do that now. So the real question here is, okay, stare decisis, as you know, is still a very, very important principle and used primarily in the courts in making law, case law. Well, we have three levels of courts. What's the, how would you describe the impact of the doctrine of stare decisis in constitutional lawmaking as compared to other courts where other laws are being made? Stare decisis requires courts to follow prior court decisions. So the question is here, is the Supreme Court bound by stare decisis and has to 100% of the time follow prior court decisions?
No.
No, so how would you describe the impact on a scale of 1 to 10?
5.
It has some impact.
Yeah, they refer to it a lot.
They do want to know what prior cases have said about things. How else are they going to know whether they want to change it or not, if they don't know what the prior cases have said? Maybe just a little more than 5. In other words, it's not as great of impact in the Supreme Court decision-making as it would be in the lower courts, where they're required to follow law.
Wouldn't you say it's lessened over the years too?
No, I don't think so. Maybe from a standpoint, no, I don't think so. Now, if the court has a more conservative, leaning, stare decisis becomes more important. Whereas in the liberal part of the court, it's not quite as important. So we have a court right now that's kind of in the middle, 4 and 4. The president will make the selection soon after. Number 10, what amendment to the U.S. Constitution guarantees the protection set forth in the Bill of Rights from state government? Anybody have the answer?
14th Amendment.
The 14th Amendment, that's correct. 14th Amendment, and you might want to put in there, it was enacted in 1868, 77 years after the Constitution was enacted, or after the Bill of Rights were enacted.
Isn't that when the Civil War ended?
What?
Isn't that when the Civil War?
That was during the Civil War, right at the end of the Civil War. That's why we fought the Civil War.
Was that when they enacted it though?
Sure.
Did you say 17 or 1868?
1868, the enactment of the federal 14th Amendment. It's called the Equal Protection Clause. And what the Equal Protection Clause does is it takes those 10 amendments found in the first 10 amendments to the Constitution and now applies them all to state governments. Up until 1868, they only applied to the federal government. These are only personal rights established by the Bill of Rights against federal government action, because that's what the framers were only concerned about, this new government they were creating. But obviously, it must have worked so well that in 1868, they adopted the 14th Amendment that also applies them to state government action, mainly by police, what they do and how they do it.
Didn't it, they do it to apply it so that slaves would be protected under the laws?
Not just slaves.
But in states where they would make laws where they'd have no protection?
Slaves were included to some extent. No, it was more for the general citizenry of the country, not just, for federal government action, because state governments were beginning to do bad things to people and had for a long time. Number 11, what amendment to the U.S. Constitution gives a person accused of committing a crime the right to remain silent and not to testify at trial? The 5th Amendment, We all know that one, don't we? Letter B deals with administrative agencies, and I touched on those last week, so we'll talk about them again here. Administrative law comes from the rules and regulations and the decisions made by agencies at both the national and state government levels. The power to make these rules is conferred in an enabling legislation. Today, administrative agencies regulate almost every part of our lives, and especially in businesses. Number one, I'm going to speak primarily, or I'm just going to speak to the federal government level, although the answers will be the same for the state government level. But number one, what branch of the government creates an administrative agency?
Executive.
I'm sorry, I didn't hear the right answer.
Legislative bodies.
The legislative branch. Now, the legislative branch of the federal government is called
Congress.
Congress. The legislative branch for the state of California, it's called the state legislature. Number two, what is the name of the first administrative agency created by Congress? So just the use of the word Congress to tell you what government I'm talking about, the federal government. And what was it intended to regulate?
Interstate commerce.
Interstate commerce in 1887. Most of the time when there's a new law made, an enabling legislation, it's given a name, okay? And this one is called interstate commerce, and they also use the year. I guess so that we all know what year it was enacted, 1887. And what was it intended to regulate? What industry?
Railroad.
The railroad industry. Number three, during the first 60 years of the development of economic agency or administrative agencies, the focus of the legislation was on what kind of issues? Economic. And during the last 25, 30 years now, the focus has shifted over to what kind of issues? Social issues. Doesn't mean that economic issues still aren't concerning. What was Dodd-Franklin a couple of years ago, regulating not only banks but other financial institutions, and really was very broad sweeping. Not only did it create a new agency, it also established, the general parameters of what have now become new rules and regulations. It was an economic purpose behind that new law. Number four, what's the name of the case decided by the United States Supreme Court in 1944 that reflected a major change in the attitude and viewpoint of the court towards the rules and decisions of administrative agencies?
Yakis?
Yakus. It's called United States versus Yakus, Y-A-K-U-S. To enforce the rules, number five, to enforce the rules by administrative agencies, the agency is given by the enabling legislation powers which are divided into two aspects. Letter A, investigation powers. The key word in this question is the word enforce. Circle it. And the question number 5, the second word is the key word, to enforce. The rules made by the administrative agency. The agency is given by the enacted legislation powers, authority, which are divided into two aspects. Number 1, investigation powers, and number 2, adjudication powers. Adjudication powers is nothing more than conducting trials. And within that adjudication process, you have hearing officers, you have prosecutors. All of these are paid employees of the agency. What does the phrase exhaust administrative remedies mean? Didn't talk about it last week, so I guess I'll have to talk about it a little more now. If an administrative agency in its enforcement powers, and that means in their investigation, finds out that you have done something wrong, whether it's an individual or your business or whatever else, they most likely will try to file some kind of charges, or they'll send a letter to you telling you that they have investigated you and that you have done certain things wrong, and we're now going to adjudicate you. See the second part of the enforcement aspect? That means you're gonna have to come in and explain what you did and try to convince us that you didn't do anything wrong. And you can have a hearing. The hearing will be for an administrative law judge, an employee of the agency. And if you don't like the decision of the administrative law judge, then you can appeal it. But you appeal it within the agency to another judge or hearing officer. And then they also allow you to appeal again if you don't get the right result. There can be 3 or 4 or 5 different appeals within the agency. This is what the phrase exhaust your administrative remedies refers to. Exhaust means use up all the remedies within the agency. And you cannot go to court until you have exhausted all of your administrative agency remedies. Now, I'm going to give you an example of a state administrative agency. It's called the Department of Motor Vehicles. And if for some reason you get a letter from the Department of Motor Vehicles telling you that in their opinion you have committed too many driving offenses, you've broken the rules too many times, and your license is being suspended, period. They will say, however, that if you want to come in and challenge that ruling, we can set up a hearing for you. We'll provide you with an administrative law judge, and you can come in and explain that. The police officer will probably come in of your last offense and explain that too. Or the hearing officer will have your DMV record and ask you to say what you think about it. Well, the chances are you're going to lose, but you can appeal. The appeal will be back at the same DMV hearing office building. And you'll have a different judge, but they'll go through the process again. And you can do it again. There's about 3 appeals at the DMV on this question of whether your license is going to be taken away or not. Now, at the last hearing, they will take your license away. They'll ask you for it and they'll take it away. Now your only recourse is to just live with it and probably drive without a license, because I don't know how you can survive without driving. Although Uber is getting better at it. And some of the other companies called Lyft and whatever else. Not so much here in Orange County yet, I don't think. But, or you can go to the court and ask for what is called a writ of prohibition, which you're asking the court to prohibit the DMV for taking your license. Your chances of winning at the court are, again, slim and none, because of the case of the United States versus Yackas that decided that when there's a hearing coming from a ruling coming from an administrative agency, that decision is presumed to be final, is presumed to be reasonable, and you're going to have to prove that it's not reasonable, and that's hard to do. How do you ever prove a negative anytime? It's hard to do. Well, most agencies, number 7. While most agencies are created by legislation made by the legislative branch of government, the agency once created is a part of what branch of government?
Executive.
The executive branch. Good. Okay, now, really quickly, onto the questions at the board. What was the name of the very first form of central/national government in the United States in 1781?
The Articles of Confederation.
Well, it's asked for the form. What was you're correct about that's what created it, but what form is it called? Confederal. C-O-N-F-E-D-E-A-L, confederal. What is the form of the national government created by the Constitution in 1787? No, the form. What form?
Democracy?
No, you're the one who answered it before.
Federal government.
Yes, federal. Federal. What's the difference between these two forms, confederal and federal?
The federal government has federal government at its heart, at the center, and the confederal has the state as its center.
Okay, let me put it this way, not quite, but close, okay? The confederal form of government was a creation by the states of a confederation or a federation among the states. They felt the need to have an agreement between the states. There were 13 states at the time. Dealing with certain subject matter, the two subject matters that were most interest were interstate commerce and foreign trade. And they needed some central organized body that would help control those two aspects of the national life. So they created the Articles of Confederation, in which the states gave over a part, just part, of their power and authority over those two matters to the new central government. And they said, here, new central government, we want you to regulate these two aspects of our nation's life. However, we will keep the right to veto anything we do. You see how weak the new national central government was under the Articles of Confederation? And what made it even weaker is they didn't have any power to get money. They were dependent solely upon the states to just voluntarily give them money to support themselves. Well, obviously, it wasn't working very well, and so it led to a constitutional convention where the representatives were charged with amending the Constitution. That's what they intended to do, not the Constitution, amending the Articles of Confederation. Probably to give a little more authority to the central government and a way for the central government to get some money. Well, there was an awful lot of debate for over 3 months in Philadelphia over what to do. They knew they were supposed